Exam Scholar, Real Estate Edition.
Question 1. A special type of appraisal used for property tax purposes is called A. An assessment. B. An appraisement. C. A survey. D. An estimate. Answer. A. An assessment is a special type of appraisal used in determining property taxes. Question 2. If a tenant has been defiantly not paying the required rent to the landlord has the right to personally evict the tenant. B. Change the locks. C. Bring court action. D. Harass the tenant with phone calls day and night. Answer. C. In regards to tenant and landlord relationships, the Landlord-Tenant Act in most states has clearly defined court procedures with timelines for the eviction process. Question 3. Which of these is associated with a deed? A. Defeasible fee. B. Alienation clause. C. APR. D. Hypothecation. Answer. A. A defeasible/indefeasible fee is associated with a deed. The other listed choices are associated with a mortgage. Question 4. What does the term alienation mean? A. Recording of judgment. B. Prescribing of a lien. C. Transfer of title. D. Exclusion of passage. Answer. C. The term alienation means transfer of title. Question 5. The power of attorney means A. A broker is an attorney at law. B. A broker can execute contracts on behalf of the principal. C. A broker is able to sue in court. D. None of these. Answer. B. Of the answers provided, the power of attorney grants the broker the power to execute certain actions on behalf of a principal. Question 6. Although an agent working under a broker is an independent contractor, the broker is still responsible for A. Making sure the agent completes tasks on time. B. The legal licensing and ethical activities of the agent. C. Providing a safe and hospitable work environment. D. The assignment of tasks and duties of the brokerage. Answer. B. The broker is required by law to be responsible for the legal licensing and ethical activities of the agents associated with the brokerage. Question 7. What is the doctrine of caveat emptor? A. A code of ethics. B. A doctrine of tenant rights. C. Let the buyer beware. D. Must be signed at closing. Answer. C. Caveat emptor is a Latin phrase meaning let the buyer beware. Essentially, it proclaims that the buyer must perform their due diligence when purchasing an item or service. Question 8. Mark, the seller, did not disclose the special assessment that will be due to the new owner in the near future after the sale is made, even though Mark knew of this development beforehand. In this case, Mark A. has done nothing wrong. It is only the agent that is bound by disclosure. B. has committed fraud. C. has been unethical but not illegal. D. none of these. Answer. B. Both agents and sellers have the commitment to disclose any and all pertinent facts about a property. Question 9. If a broker shows a home to a potential buyer and they wish to make an offer on it, what legal responsibility does the broker owe the customer? A. Honest and fair treatment. B. Fiduciary duty. C. Confidentiality. D. Exclusivity. Answer. Because the potential buyer is a customer of the broker, the only obligation the broker has is to treat them fairly and honestly. There is no fiduciary duty. Question 10. What legally obligates the buyer to pay the broker's fee? A. The exclusive right to represent. B. The broker protection clause. C. The legal rights of fiduciary duty. D. The contract. Answer. B. Unless the buyer hires another broker and then buys a property, the broker protection clause obligates the buyer to pay the broker's fee.
Passing the real estate exam can be hard, like really hard. Statistically, only about 50% of people actually pass the real estate exam on their first try. Those people that pass, they go on to become real estate agents. And the people that didn't pass, they either give up completely or have to try again. Both of these options are painful, disappointing, and upsetting. Exam Scholar Real Estate Edition has been named as the best real estate exam prep by multiple publications for 7 years in a row. If you are about to take the real estate exam, Exam Scholar Real Estate Edition is a no-brainer choice. There is no other real estate exam preparation service out there that comes close. To enjoy the longest membership time, lowest cost, real estate videos, audios, articles, flashcards, vocabulary, exam tips and tricks, a 1-year no questions asked refund policy, and be one of the 35,000 people that it has helped pass the real estate exam, then sign up in less than 5 minutes at www.realestateexamscholar.com.
Question 1. If you are looking at the note rate, you are looking at A. The interest rate stated on a mortgage note. B. An amount that has been pre-qualified. C. The rate of depreciation of a real property. D. None of these. Answer. A. The note rate is the interest rate that is stated on a mortgage note. Question 2. The National Association of Realtors, NAR, is affiliated with which of the following? A. The American Institute of Real Estate Appraisers. B. Institute of Real Estate Management. C. The Farm and Land Institute. D. All of these. Answer. E. The National Association of Realtors is affiliated with 9 institutes, councils, and societies. The American Institute of Real Estate Appraisers, the Institute of Real Estate Management, and the Farm and Land Institute are 3 of these affiliates. Question 3. What causes the real estate market to be considered inflexible? A. The lack of control of factors determining values of property. B. The immobility of land as well as the time required to develop new properties. C. The ability to quickly react to market demand fluctuations. D. The similarities of properties in a general geographic area. Answer. B. Because each property is unique in real estate and cannot be moved, this creates a slowness to respond to market demand. Question 4. Uniqueness in real estate properties is sometimes called A. Situs. B. Conforming. C. Self-same. D. Unvaried. Answer. A. Situs is a term of law, originally meaning site, where the property is treated as being located for legal purposes. This uniqueness of place in real estate is also called situs. Question 5. The mortgage that usually has priority is A. The one that has been recorded first. B. The one that has no prior liens affecting its priority. C. The one that is executed first. D. None of these. Answer. A. The priority of a trust deed or mortgage is established by recording. The one that is recorded first gets priority. Question 6. If an agent is to get the commission for a long-term lease, the commission would be paid out A. Immediately for the full amount of the lease. B. Each month over the life of the lease. C. In a lump sum for half the lease amount and monthly thereafter. D. None of these. Answer. B. Typically, the lease compensation is calculated based on the full and total amount of the lease but paid out monthly over the term of the lease. However, in extremely long leases, the compensation is typically paid out monthly for the first few years of the lease and a lump sum thereafter. Question 7. In order to set commission rates, the contract between the principal and broker should A. Be in writing stating rates are set by statute. B. Be in writing stating that rates are negotiable. C. Be an oral agreement if not written. D. None of these. Answer. B. Commission rates are not set by statute. The commission rates between the broker and principal are negotiable. To establish this and avoid lawsuits, this should be in writing. Question 8. If a mortgage note was executed and a new loan was established on the same property at a higher interest rate, the prepayment penalty could be A. Waived due to recouping losses through a higher interest rate. B. Waived because of the understanding nature of the lender. C. Charged regardless of any interest rates. D. None of these. Answer. A. Because a prepayment penalty is instituted by a lender to recoup any lost interest charges due to early payoff of a mortgage note, a lender could waive the prepayment penalty if a new loan on the same property is issued at a higher interest rate. Question 9. If an advertisement is offering a secured loan, the ad must include A. The loan is secured. B. To what extent the loan is secured. C. How and to what extent the loan is secured. D. Who is securing the loan? Answer. C. Disclosure of how and to what extent a loan is secured must be included in any advertisements offering secured loans. Question 10. If a farm is sold that has a full crop of annual vegetables ready to be harvested, what conveys as real property? A. Trees. B. Air rights. C. Mineral rights. D. All of these. Answer. D. The annual crops are considered personal property of the person who planted them. The trees, air rights, and mineral rights convey with the sale of the property. Question 1. Which of the following best describes a complete escrow? A. It is considered a perfect escrow. B. The escrow holder has ceased being an agent for both parties. C. All papers are properly drawn up and ready for final steps to be taken to close the escrow. D. All services of the escrow holder are involved. Answer. C. The settlement in choice C describes a complete escrow. Usually an escrow is complete in the evening and closes the following morning when the deed is recorded. Question 2. When a legal description uses only sections, townships and ranges, the lines relate to the A. Government survey lines. B. Contour lines. C. Recorded tract map. D. Meets and bounds descriptions. Answer. A. Sections, townships and ranges are used in government surveys in describing the location of land. Meets and bounds description outlines a certain area. Question 3. A lender would be exempt from the requirement of providing the borrower with a federal right to rescind notice except A. If the loan is for more than $25,000 and is not secured by the borrower's personal residence. B. If security for the loan is commercial property.
C. If the loan is for business expansion.
D. If the borrower is refinancing. Answer. D. A negative question. Refinancing your personal residence is not an exemption and is fully covered by a 3-day right of rescission. Question 4. Fisk owns a lot. He also owns a right-of-way easement over the property of his neighbor, Smith. This easement is appurtenant to Fisk's lot. Fisk sells his lot to Jones without specific mention of the easement in the deed. The easement A. Remains with Fish as an encumbered interest. B. Passes to Jones. C. Terminates unless it is a covenant running with the land. D. Reverts to Smith. Answer B. Appurtenant easements run with the land and automatically pass to future grantees, whether mentioned in the deed or not. Question 5. Which of the following would normally install conduit? A. Plumbers. B. Electricians. C. Roofers. D. Carpenters. Answer B. Electrical wiring is placed inside a metal pipe called a conduit. Question 6. Two people entered into a land contract for the purchase of a home and the contract was recorded. A few months later, the vendee abandons the property and defaults on the contract. If the vendee refuses to execute and record some form of release, it will A. Not affect the marketability of the property. B. Result in a deficiency judgment. C. Result in a trustee's sale. D. Create a cloud on the title. Answer D. A recorded land contract show an equitable interest in the property. When the vendee, buyer, defaults and abandons the property, the land contract becomes a cloud on the title until it is removed by either a quitclaim deed or a quiet title action. Question 7. A broker who is hired by an owner to sell his property must reveal all significant and material information to the principal. Which of the following would be considered material information and must be revealed? A. The new lender will require the buyer to maintain an impound account. B. Agent's knowledge that a better offer to purchase is imminent. C. The prospective buyer is of Oriental descent. D. None of the above. Answer B. The existence of a better offer that is imminent could very well be a material fact to the seller. It would probably influence his decision on a present offer. Question 8. Generally, the most important determinant of a property's value is A. Age. B. Utility. C. Location. D. Income. Answer C. Location is the most important factor influencing value, the other factors being utility, size, shape, thoroughfare conditions, exposure, character of the business climate, plottage or assemblage, character of the soil, grades, obsolescence, building restrictions and zones. Question 9. Real property includes the land, those things attached to the land, and thing called appurtenances. Appurtenances include all of the following except A. A dwelling. B. Trade fixtures. C. Watercourses. D. A fence. Answer B. Trade fixtures are considered personal property. Question 10. How many acres are in the west half of the south half of the south half of the south half of section 27? A. 20 acres. B. 40 acres. C. 80 acres. D. 160 acres. Answer B. Section 27 equals 640 acres. S half equals 320 acres. S half equals 160 acres. S half equals 80 acres. W half equals 40 acres. Question 1. Which lien has the lowest priority for collection? A. Special assessments. B. Property taxes. C. Mortgages. D. Unsecured court order. Answer. D. An unsecured court order would have the lowest priority of the listed answers. Property taxes, special assessments, and mortgages generally have priority. Question 2. In a case in which the seller refuses to pay the broker a commission and the broker does not sue the seller, what can the sales agent do to receive the commission due to him/her? A. Sue the seller. B. Sue the broker. C. Place a lien on the property. D. Sue for specific performance. Answer. B. The only real recourse that a sales agent would have in this situation is to sue the broker for the commission. Only a broker can sue the seller/principal. Question 3. If Mike, an attorney, sends Misha, the sales agent, a crisp $100 bill in an envelope to her office in return for referring her client to him, under the rules of RESPA this would be A. Legal. B. Illegal. C. Shady business practices because the money should not be cash. D. None of these. Answer. B. Under the rules of RESPA, this type of action would be illegal because it is considered a kickback. Question 4. RESPA does not regulate A. Booklets. B. That lenders make a good faith estimate of closing costs. C. Rates. D. That the HUD-1 uniform settlement statement be used. Answer. C. RESPA does not include anything about rates. Question 5. Even if a person has a low creditworthiness, the Fair Housing Law requires A. That the lender make the loan anyway at a higher interest rate. B. That the lender make a good faith attempt to obtain a loan. C. That the lender reconfigure the loan requirements to fit the individual. D. None of these. Answer. D. The Fair Housing Law does not require that a lender perform any of these actions if the individual does not meet the required creditworthiness. Question 6. The seller delivers the deed to the property and the buyer pays the purchase price in the step known as A. Ending. B. Closing. C. Final. D. Deadline. Answer. B. The transfer of title and settlement of accounts is called the closing. Question 7. Depreciated value is considered in which approach? A. Cost. B. Sales comparison. C. Income. D. Gross rent multiplier. Answer. A. The cost approach considers depreciated value, which is estimated. Question 8. James was able to have his building permit issued without issue even though there was this violated restriction. A. Deed. B. Zoning. C. Building code. D. Setback. Answer. A. A deed restriction is not enforced by local building authorities and are non-governmental. They are issued by the previous owner of the property and can be enforced through neighbors' lawsuits. Question 9. If a real estate agency relationship is to be enforceable, which of these needs to happen? A. Be authorized by a written agreement. B. The agent must be a valid licensee. C. The principal must have the power to do what is being assigned. D. All of these. Answer. D. In order for the real estate agency relationship to be enforceable, all of these criteria must be met. and in some cases more than these. Question 10. If a homeowner wishes to receive monthly checks or a lump sum based on the equity in their home that does not have to be paid back until either the property is sold or the owner dies, they would need to obtain A. A circular mortgage. B. Comprehensive mortgage. C. Reverse mortgage. D. Applied reverse mortgage. Answer C. This type of tapping of equity in a home is called a reverse mortgage. Question 1. In portfolio risk management, a lender considers A. Diversification. B. Liquidity. C. Reserves. D. All of the above. Answer D. In portfolio risk management, a lender determines what type of loans to have in his portfolio. Factors are: how quickly can I sell these loans? What are my reserves? How diversified are these loans? Are they all business? Are they all residential? Are they a mixture of business and residential? Question 2. You sell a note with a face value of $12,000 for $10,000. You are A. Discounting the note. B. Amortizing the note. C. Committing an act requiring a real estate license. D. Committing fraud. Answer A. Anytime you sign a note or sell a note and the amount you receive is less than the account stated on the face of the note, you are discounting the note. Question 3. An able buyer means one is A. Financially able. B. Having the ability to obtain the necessary funds to purchase real property. C. Having the ability to obtain necessary financing. D. Any of the above. Answer D. Any of these would indicate an able buyer. Question 4. The right to foreclose a trust deed, under a trustee's power of sale, outlaws A. In 4 years. B. In 3 years. C. In 2 years. D. Never. Answer D. A trust deed is not a contract, but rather a conveyance of the naked legal title with the power of sale from the trustor to the trustee. Therefore, the trustee retains the right to sell the property under the trust deed at any time for the benefit of the beneficiary. The conveyance has been performed and thus is not under the statute of limitations, therefore, it never outlaws. Question 5. Broker Styles took a listing from a seller using the standard listing form. 1 week before the listing expired, the broker informed the seller that he had a prospective buyer named Bennett. After the listing expired, the seller listed with broker Johnson. Johnson showed the property to Mr. Bennett and obtained an offer that was accepted. Under these circumstances, A. Broker Styles gets a 6% commission. B. Broker Johnson gets a 6% commission. C. Both brokers get a 6% commission. D. Broker Styles gets a 3% commission and Broker Johnson gets a 3% commission. Answer B. In the safety clause of the standard listing form, Broker Styles would agree to relinquish his safety period if the property were listed with another broker. Question 6. A loan created with more than one borrower is usually added to the promissory note for the protection of the lender. A. Beneficially. B. Jointly and severally. C. Universally. D. Unconditionally. Answer B. When there is more than one borrower on the note, The promise and obligation to pay that balance is the responsibility jointly of all the co-borrowers, and also each individual is severally liable for the full debt. Severally, in law, means individually. Question 7. Mr. and Mrs. Johnson, who had been shopping for a new home, found one that they liked very much, but because they felt the property was overpriced, they decided not to buy it. Their reason for not buying was probably based upon the principle of A. Conformity. B. Substitution. C. Highest and best of use. D. Anticipation. Answer. B. It must be assumed that our buyer has found another home that was equally desirable but at a much lower price. This is the idea behind the principle of substitution. Question 8. When a broker misrepresents his principal's property to a buyer, he could cause his principal to be subject to A. A court action for damages by the buyer. B. A rescission of the sale by the buyer. C. Civil responsibility for compensating the buyer for misrepresentation of the broker. D. Any of the above. Answer. D. The principal is responsible for his agent's actions. If misrepresentation occurs, there should be a rescission of the sale or civil court action for damages. Question 9. An owner of a 5-unit apartment building that is located within the city limits intends to convert the building into 5 condominium units and offer them for sale to the public. Under these circumstances, the developer A. must obtain a public report from the Real Estate Commissioner under the Subdivided Lands Act. B. must file a map with the city under the provisions of the Subdivided Map Act. C. is exempt from the Subdivided Lands Act and the Subdivision Map Act. D. must comply with the Subdivided Lands Act and the Subdivision Map Act. Answer. B. Any type of subdivision located within the city limits is exempt under the Subdivided Lands Act, but a condominium conversion of 5 units or more is covered under the Map Act and must be filed with the local authorities. Question 10. After acquired title is conveyed in any trust deed for the benefit of the beneficiary, it conveys A. personal property later affixed to the real property so as to become real property. B. improvement built on the land after title is acquired. C. additional land acquired afterward by the truster. D. all of the above. Answer. D. After acquired title refers to title to fixtures or other real property items that become part of the land that is securing the existing trust deed. If a lot serving as security for a loan made 10 years ago has land affixed to it, that land becomes encumbered with the lien made 10 years ago. If additional improvements, such as a swimming pool, added bedroom or new landscaping are added to the real property, they to become encumbered with a trust deed lien made 10 years ago.
Exam Scholar, Real Estate Edition.